Good afternoon, everyone. We're here for the afternoon session of first appearances. I'm Judge Corey Amanda Cawthon. We will begin with the first appearance docket and then go to our hearing docket. Just a reminder to everyone that everything that we say is being recorded and can be used against you at a later date. And so I do encourage you to speak to your attorneys before speaking on the record today. Before I do go to our first appearance docket, I have one case to be called out of turn. If we have him present at the jail, on our felony hearing docket, on page 3, Cameron Hobdy.
No problem.
Thank you. His mother is present in the courtroom. Good morning, Mr. Hobdy.
Good morning.
Or good afternoon, excuse me. All right,
Okay.
so Mr. Hobdy's here on a second look. And let me just see what I have here. What is his bond currently set at?
$1,200, Your Honor. He's got, I believe the count one is actually an attempt, resisting without loitering or prowling. He also has a misdemeanor possession charge in front of Judge Lerner Wren. That charge he has been released on his own recognizance.
Okay. All right, so before I hear anything further, we have Mom present. Are you here just to observe or to speak? No, not you, Mr. Hobdy. I'm just speaking to your mother right now. Yes,
Judge,
ma'am.
I believe the court will want to inquire Mrs. Hobdy's mother regarding her, where she lives and things like that, whether or not he's going to be able to stay with her. We're seeking to have the court grant either ROR or pretrial release to Mr. Hobdy to allow him to get counseling on the outside, and Mom is here to support that. And
All right. Okay, Mr. Linder, what do you have to tell me on your side of things?
Spoke with Mr. Miller. I would be okay with him being released to pretrial with a GPS monitor. It shouldn't result in any delays because his mother's here, and if his mother's saying that she can reside with her, okay. My concern is that, and I can advise the court, I spoke to his other cases in front of Judge Lerner Wren.
Yes.
And part of the consideration that she gave to RORing him on a capias in front of her was that she was advised this case is going to be downfiled to a trespass. I advised her I'm not aware of, there are no notes in the system indicating that. That being said, if he needs help, mental health treatment, okay. But I would ask for a GPS because my understanding, Mom, was he residing with you end of January?
He resides with me permanently, yes.
So, I mean, it's still the same environment that where, he did get arrested for an attempted burglary. So a little extra supervision, I think, would be appropriate.
Judge, if the court does think a GPS is appropriate, we would ask if he could have an open schedule because they still have to set up all of the appointments and the doctor visits and all of those things still have to be done. And setting and keeping a schedule would be problematic, I think, under the circumstances.
Your Honor, I don't know. I think it actually would be a good thing to have a schedule. Everything that's being talked about is things that are set up in advance. None of these things are
Right.
spur-of-the-moment appointments set up at Henderson.
I understand. Okay. What I'm willing to do based on the fact that Mr. Hobdy's mother is present, indicating he's going to reside with her, and the information that everyone's given to me regarding him potentially seeking some sort of counseling or other treatment, then I would be willing to ROR him and release him to pretrial, but I do believe that having him on a level 2 GPS monitor may be the best thing for him right now. Obviously, if there are appointments and things to be made, those can be cleared with pretrial as part of him being on their supervision with a level 2 GPS monitor. So at this time, I will grant the request, and he will be released to pretrial and put on a level 2 GPS monitor. I assume there was already a no return order put in place.
I believe so, but if you want to just,
All right.
Your Honor, actually, just, you may recall, this, when Mr. Hobdy first came through, it was over the weekend before Judge Barner.
Okay.
It was up for perfection. You found PC
Yes.
for attempted burglaries.
Yes.
I don't think he was even present for the perfection. You said $1,000 bond. It was reset for a second look, or he came through for a second look. It was medical reset at that time.
Okay, I think I do remember that. All right, so Mr. Hobdy, I just want to advise you, in addition to the other release conditions that I'm putting in place today. There is a no return order. That means that you are not to return to the location that this allegedly occurred at. Do you understand that?
Yes.
Okay. So what will happen is someone from pretrial will go to Mr. Hobdy there in the jail and have him fitted for the GPS monitor before he's released.
Okay.
All right? Okay, thank you. Good luck, Mr. Hobdy.
Thank you, Judge.
Thank you. Good luck. You need her? Okay, don't leave yet, ma'am.
No, Ed.
Okay. All right, let me go to Maine. Is there anyone at Maine that needs to be taken out of turn before I get started?
No, Judge.
Okay. Thank you. I appreciate that, Teresa. All right, we have two cases that were reset from this morning, so if I have them present, we'll take them first. The first one I have up is Jaden DeRosa.
Mr. DeRosa, come on up, please. He's approaching, Judge.
It's from this morning.
I did receive the supplemental probable
Yeah.
cause affidavit.
Yes, Your Honor, I believe there were issues in the original PC with how Mr. DeRosa and Mr. Clark were identified.
Yes, I did notice that. All right. Good afternoon, Mr. DeRosa. Mr. DeRosa, you are before the court on two charges. Count 1 is for burglary of an unoccupied dwelling unarmed. 2 is for criminal mischief. $200 under $1,000. Based on the probable cause affidavits, both of which have been provided to me, I do find probable cause for these charges, and I will hear from the parties at this time.
Judge, my understanding, speaking with Mr. DeRosa, I believe he has a clean record. He did tell me he had a prior arrest in Dade County, but he believed that was dropped. Now he's 19 years old, been here since he was 11 years old. He's a graduate of Coral Glades High School, class of 2018. He just got a job approximately 3 months ago at a tax office where he's basically works the front desk as a sort of receptionist, where he's making $12 an hour. Now, he's been saving up. His goal is to be enrolled this summer at Broward College. He wants to pursue a criminal justice degree. Judge, he lives in North Lauderdale with his aunt. He believes his family is going to try and do their best to try and help him post a monetary bond, but at most they're going to be able to afford using the services of bondsman $3,000. That's what we're requesting on count 1, a $3,000 bond on Mr. DeRosa's behalf, Judge.
Thank
The
you.
state would be requesting a $10,000 bond, no victim contact, no return. This involves someone's home. Additionally, Mr. DeRosa is mistaken that his case in Dade County was dropped. He does have a pending charge of carrying concealed firearm. It is set for trial before Judge Millian, April 13th of this year. He had a continuance granted January 21st. It's 2 weeks ago.
For the other priors besides the pending case,
That's all I see, Judge.
that was for carrying concealed firearm.
Yes.
Bond in this case will be set at $5,000. There's going to be a no return order as well as a no victim contact order, Mr. DeRosa, so that you understand those orders. That means that you are not to return to the location this allegedly occurred at. As far as the no victim contact order goes, whether you know these individuals or not, no victim contact means no being in the same place at the same time, no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes.
Thank you. Next will be Isaiah Clark.
He's here present, Judge of Maine.
Thank you. Good afternoon, Mr. Clark.
Good afternoon.
Mr. Clark, you are before the court on two charges. Count 1 is for burglary of an unoccupied dwelling unarmed. 2 is for criminal mischief, $200 under $1,000. I find probable cause, and I'll hear from the parties.
Now, Judge, my understanding, speaking with Mr. Clark, from speaking to him, he did advise me as prior contact. He believes it was for misdemeanor offenses of loitering and prowling, second-degree misdemeanor. Now, he's been here his whole entire life. He's 19 years old. He's looking for employment, but besides that, he's going to school. He goes to Siegel High School. They have a program which allows him to recuperate credits. My understanding, Judge, if he's on track, he'll be able to graduate this year. He goes to school, from what he advised me, Monday through Friday, 9:35 a.m. through 3:45 a.m. He lives with his aunt. My understanding is, from what he advised me, his aunt barely is able to pay the rent. I believe they pay $1,200 a month, so he's absolutely sure she's not going to be able to pay his bond. She also supports her 3 children, so financially they have no resources. So he's asking, Your Honor, to be released on supervision. I do understand this is a burglary, Judge. That's why I'm going to be requesting level 2 supervision, so at least that's basically house arrest, but they will allow him to go to school on level 2, so that's why I'm asking for level 2 and not level 1, Judge.
Actually, I'm requesting a $5,000 bond, same with his co-arrestee. Pursuant to Florida statute, he's not entitled to release the pretrial at first appearance for a burglary of a dwelling, Your Honor. I would also note, while the charge was dropped, he was arrested less than 2 months ago in Pinecrest in Dade County for loitering and prowling, which is closely related charge to burglary. My concern is it's not just him going to school. If this type of conduct continues, he's going to end up either in state prison or going into people's homes. He could end up getting hurt himself, or or residents of homes getting hurt.
Bond in Mr. Clark's case is going to be set at $5,000 on count 1. There will be a no victim contact order as well as a no return order. Mr. Clark, so that you understand those orders, no return means that you're not to return to the location this allegedly occurred at. No victim contact means no being in the same place at the same time, no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, ma'am.
Thank you. All right, next will be Ashley Rivera.
Judge, North Broward Medical Reset.
Okay, thank you. Shan and Boyko.
Also North Broward. She believes that, I think they're bonding her out now as we speak.
Can I check with confinement? Can you verify that for me on Boyko?
This is information I got from the deputy there.
Okay. Let me check with them and see what's going on. Not posted. All right, do they have her there at North Broward so I can just see her? If they're gonna be posting her bond, then we don't need to change it, but if she's there, I'd like to at least see her. Deputy, do you have Ms. Boyko? They're telling me here that her bond is not showing that it's been posted in the system.
We would have to go get it from the unit.
Okay, well, let me ask Mr. Miller, if you're representing her, do you want to waive her appearance?
Judge, I'm willing to waive her appearance if the bonds are being posted, then it's just a matter of everybody catching up with everyone else. We would ask the bonds to be kept as currently set.
Okay. Mr. Linder, do you have anything else on Ms. Boyko's case?
No, Judge.
All right, then for the record, I do find probable cause, and I will leave her bonds in place as is. Thank you,
Okay,
Deputy.
Thank you, Judge.
Thank you.
All right. Next will be Selvin Soto.
He's at the Paul Ryan, Judge.
Thank you. Okay, let's see here. Is this a change of charge and an add charge? What's going
Yes,
on?
Your Honor, the change of charge was technically up 5.
Good afternoon, Mr. Soto. All
Good
right,
afternoon.
which is the change of charge, the burglary?
The burglary was technically upfiled.
All right,
Um,
to a burglary of an unoccupied dwelling.
Yes, bond was originally set at 2,500. I'm fine with that, considering he's got a $25,000 bond on another count, and no bond hold on another count.
Okay, and the petty theft charge is an ad charge?
Yes.
Okay. All right, for the record, I find probable cause. Mr. Miller, on the burglary count, do you have any objection to the bond remaining as is?
No, Your Honor.
All
We're
right.
fine with that.
And then, does anyone have anything to add on the petty theft charge? Okay, so that will remain at $100 standard bond, okay? All right, so Mr. Soto, you've got an additional charge for petty theft with a $100 bond, and the burglary charge, as you heard, has been upfiled, but the bond is gonna remain at the same amount on that one. Yes, ma'am. All right, good luck, sir.
Thank you.
Jonathan Grant,
Conti, Judge.
thank you. Good afternoon, Mr. Grant.
How you doing?
I'm well. All right, you are here on 2 ad charges this afternoon. Each of these is a separate count for false identification given to law enforcement. I do find probable cause. Do the parties wish to be heard?
No, Your Honor, Mr. Grant has a $3,000 bond on a strong arm robbery on a different count.
All right,
Judge, in light of this current situation, we have no objection to the bonds being kept as set.
okay. All right, so the bond will remain in place on count 4 is the only one that has the bond right now that's at $100. Okay? All right, good luck, Mr. Grant.
All right, thank you.
Thomas Rigetti,
He's approaching, Judge. He's here with me. Come on
thank
up,
you. Good afternoon, Mr. Rigetti. Mr. Rigetti, you're before the court this afternoon on a misdemeanor capias. This relates to a charge for trespassing. I find probable cause, and I'll hear from the parties.
Judge, I told Mr. Roggetti what the docket indicated, that he missed court for a trespass.
Yes.
He wanted me to ask the court if the court would consider resolving the case, so we wanted to see if the state had a plea offer for him
This is
today.
actually an MO, Judge.
I'm sorry?
It's an MO. If you look at
an
the
MO.
PC affidavit,
Oh,
it's
wrong case
in
number.
the capias, it's an MO. It was just booked incorrectly on an MM.
okay. Let me, I'm gonna make the correction to my finding sheet. It's the right case number, it's just MM instead of MO.
Judge, Mr.
Yes.
Plant was here earlier. We did not realize he had any cases on the docket, so he left. Do we want to just reset him for tomorrow morning, see if we can resolve it then?
I'm sure Mr. Plant is probably, if you gave him a phone call, he'd probably answer.
Well,
Maybe if you're by phone?
let me just do this. Mr. Linder, would you mind doing me a favor and just telling me if Mr. Rigetti has any priors? And depending on what that is, we may be able to resolve it.
January 13th of this year, he was arrested on a capias on an alcohol violation. He pled that out. November 29th of last year, capias on urinating in public. He pled that out to time served. November 4th of last year, a new alcohol violation and a capias on an alcohol violation. He got time served. August 29th of last year, resisting without violence and trespass, he got time served. July 27th of last year, capias on a county violation. I don't know what specifically it was for. He got
All right,
time
that's
served.
okay. That's all that I need to hear. Okay, based on what I'm seeing, like all of the capiases that Mr. Rigetti's been picked up on, I'm going to leave the bond in place because, Mr. Rigetti, I do see that you have a hearing, a status hearing before your division judge in this case tomorrow morning anyway. So rather than me resetting it for first appearances tomorrow, I'm just gonna have him go in front of his division judge. And that way, Mr. Plant will be present and you can discuss it with the division judge to see what's to be done. All right, good luck, sir. Okay. Next will be Peter Simone.
Conti?
Thank you. Good afternoon, Mr. Simone.
Yes, ma'am.
Mr. Simone, you're before the court this afternoon on an ad charge. This is for burglary of an unoccupied conveyance, unarmed. I find probable cause, and I will hear from the parties.
Your Honor, I'm gonna ask the court to set the bond on this burglary conveyance at $1,000. I would normally ask for a higher bond, but he's being held on a $5,000 bond on the trespass
Okay,
that he was just arraigned on by Judge Merrigan yesterday.
okay.
So, based on the totality of the circumstances, I'm requesting $1,000.
All right, Mr. Miller, you have any objection to that?
No objection, Your Honor.
Okay, so, Mr. Simone, on this additional charge, your bond is gonna be set at $1,000. I do see that you have a hearing before your division judge tomorrow morning, so you'll see the division judge tomorrow.
Excuse me, ma'am.
Yes,
What burglary is this?
Your Honor, if I may,
yes, go ahead.
when Mr. Simone was arraigned yesterday,
Yes.
this was one of the counts he was arraigned on.
Oh, so he's already been arraigned on.
He was arraigned yesterday.
Okay,
The clerk's office, I guess, wasn't able to process the change of charge and add charges to have him have a first appearance on it prior to the arraignment.
so Mr. Simone, this burglary charge is the charge that you were arraigned on yesterday in front of your division judge, but you do have another hearing tomorrow morning in front of the division judge, so you can discuss the details of it with your attorney before the hearing.
But the only thing I don't understand is they had a change of charge
Yes,
that I
that's,
never been arraigned on.
He was arraigned on that as
I
well.
mean, I never went before the magistrate from burglary to trespassing, and now I'm going before you again for the same.
it's already, what you were arraigned on yesterday, typically speaking, today's hearing would have taken place before yesterday's hearing, but the paperwork couldn't get done in time. So what you were arraigned on yesterday is the correct information, okay? So
So the change of charge never happened then.
the change, which charge is that
Your
on?
Honor, he had a burglary, when he was arrested, he had grand theft auto and burglary.
Yes,
The burglary was downfiled to a trespass, and we add charged a new burglary count.
okay,
He's gonna be brought before Judge Merrigan tomorrow.
okay.
He can ask he has the public defender's office appointed. If he wants to seek any modifications of bond, he certainly is free to discuss that with his public defender tomorrow morning.
So I have two burglaries?
Yes, sir.
No, burglary and a trespass.
That's the current charge of burglary and a trespass.
Yes, ma'am. And
Okay.
a grand theft auto. But
And the grand theft auto. All right, so there's 3 charges total: grand theft auto, burglary, and trespass. And Mr. Simone, you're gonna, when you see your attorney tomorrow for tomorrow's hearing, then you can discuss that in greater detail then. All right, good luck to you.
I never seen an attorney yet.
You're gonna see someone tomorrow morning. All right, next is Anthony James. Conti?
well, one of them we did yesterday. $1,000.
It's $1,000. All right, Mr.
Judge,
Miller?
Yes, Your Honor. Under the circumstances, I'm willing to waive Mr. James' presence. This is an ad charge similar to the multitude of charges he already has.
Correct.
And we are going to, defer any arguments regarding bond or proof evident presumption great to another day.
Okay, all right, Deputy, thank you. Mr. Linder, on Mr. James's case, we are proceeding in absentia. For the record, I do find probable cause for these charges. Are you seeking?
Yes, Judge, and just a note for the record, and I don't know if this is on your findings as well, I noticed it's on the docket.
Yes.
The docket shows charges 15 and 16.
Yes,
We handled 15 yesterday.
right, it's only
We're just
16 for
handling
today.
16 today.
Okay. Just to be clear, I'm gonna cross out 15 on my finding sheet. Are you seeking a finding of proof evident presumption great?
Yes, Judge.
Okay, all right, then, I have reviewed the probable cause affidavit, as we've done with a number of Mr. James' other cases. For today's purposes, I will make a preliminary finding of proof evident presumption great in order that he be held without bond on this charge as well. That will be without prejudice for him to have the appropriate hearing before his division judge. All right, thank you, gentlemen. Next will be Deontay Davis.
Main jail.
Thank you. All right, good afternoon, Mr. Davis.
Good afternoon.
Mr. Davis, you're here on 2 ad charges. Count 8 is for false ownership information provided for pawned items less than $300. Count 9 is for dealing in stolen property. I find probable cause.
Your Honor, Mr. Davis has no bond holds and a $20,000 bond on a separate burglary of a dwelling.
Okay,
In light of that, I'm just asking that the court keep these bonds in place.
all right.
Judge, based on his no bond hold, we're not gonna be requesting anything at this time.
Okay, so for today's purposes, the standard bonds will remain in place. Thank you. Next will be Eric Redmond.
North Broward.
Thank you.
North Broward.
Thank you. Good afternoon, Mr. Redmond. Mr. Redmond, Mr. Redmond, you're before the court this afternoon on an ad charge. This is a charge for criminal mischief over $1,000. I find probable cause, and I will hear from the parties.
Your Honor, I'm gonna ask that the court keep the bond in place, issue a no contact order for T-Mobile on Sunrise Boulevard in Fort Lauderdale. As you may recall, Mr. Redmond appeared before you yesterday. The court was not comfortable even accepting a 15-day plea. In light of that, I asked that the bond would be appropriate then in this felony matter.
And Judge, just for Mr. Redmond's edification,
Yes.
this case stems from an event that happened back in November of last year.
Yes, I do see that. All right, so for today's purposes, I'm gonna leave the $500 bond in place. There will be a no return order. Mr. Redmond, that means that you are not to return to the T-Mobile store that's at the Galleria Mall on Sunrise Boulevard. Do you understand that?
Yeah, I don't even own a T-Mobile phone.
Okay, I just need to know that you understand that no return order. Do you
Yes,
understand?
ma'am.
Okay, thank you very much.
Ma'am, is there any way I can get to mental health court? I'm hearing voices and everything. These are the reason I do these crimes. Is I need mental health associated. I need help.
So, Mr. Redmond,
I
okay, hold
I
on.
mean, I'm committing crimes left and right because the voices are telling me to do so. I need help. I need a Henderson clinic or something.
Okay, Mr. Redmond, here's what I'm gonna say to you, okay? The case that is before me today is a felony case, which means that I'm not able to directly transfer it to mental health court. However, Mr. Miller, who's here from the public defender's office, can notify your assigned public defender so that they can let your division judge know, and hopefully they'll be able to get you set up with felony mental health court if that is what is needed, okay? And then you'll be able to
Yes,
get the
ma'am.
resources and the help that's necessary, all right?
And, Your Honor,
Thank you, ma'am.
Yes, yes,
for
Mr.
the
Lugar.
record, if Mr. Redmond is hearing voices, as he puts it,
Yes.
I'd have no objection to a Baker Act evaluation.
Mr. Miller?
Judge Baker Act is appropriate if he's threatening harm to himself or others. I'm not hearing that that's necessary. I will defer to the court.
Your Honor, we will, and that's the whole point of the evaluation, to see if he poses a harm to himself or others, that he is now, all of a sudden, and he wasn't saying any of this yesterday, now all of a sudden he's claiming to hear voices. I don't think an evaluation would be inappropriate.
Mr. Redmond, do you need to go to the hospital?
Yes, please.
All right, I will sign the appropriate order so that Mr. Redmond can get an evaluation done to see what needs to be provided to him at this time. All right? Mr. Redmond, I'm gonna sign that order today. Good luck to you.
Thank you, ma'am.
I'll sign that order once it's provided. Next will be Roderick Holloman.
Bonded.
Thank you. For the record, I find probable cause. Larry Gonzalez.
Bonded.
Thank you. I find probable cause. Michael Sparks.
Bonded.
All right. Why can't you guys do this in the morning? For the record, I find probable cause.
The more time you
Shaw
have-
Dane Chang.
Bond. Wait, Chen, Christopher Chen?
Chang? No. This is Chang. Chang.
Oh, no, sorry. Proceed.
Shaw. First name is Shaw.
Hey,
Shaw
Chen,
Dane.
bonded.
Okay, thank you. I find probable cause. Mark Tyndall.
North Broward.
Thank you.
Judge, that's a medical reset.
Yes.
All right. Thank you. Brandon Hansel.
Maine.
Please approach the judge. Come on up, Mr. Hansel.
Thank you. Good afternoon, Mr. Hansel.
Afternoon, ma'am.
You're before the court this afternoon on 5 charges. Count 1 is for possession of cannabis, 20 grams or less. 2, possession of heroin. 3, possession with intent to sell, manufacture, deliver alprazolam. 4 is possession of cocaine, and 5 is failure to wear a safety belt. I'll hear from the parties.
Judge, nothing to add at this time. I'm gonna be contacting Mr. Hansel's family, post his monetary bond. I don't know if the state would have an objection, just on count 1 alone, the misdemeanor possession of cannabis,
That's
if
fine.
we could ROR that count.
All right. For the record, I do find probable cause. I will grant the ROR on count 1, and the other standard bonds will remain in place at this time. Thank you. Michael McMillan,
Medical?
okay. All right, so let's go over to the hearing docket.
Judge?
Yes.
Judge, there was a couple of people I believe the court, didn't call on. Starting on page 6 of the docket, Mr. Christopher Chin.
My clerk here is telling me that there is no paperwork on those individuals. Are there multiple individuals?
On who?
Chin, Resno, and Fuster?
Mr. Renzo, Mr. Fresher are here both, and Mr. Chin bonded.
Okay. There's no paperwork on the other two? So are they being reset to tomorrow? The other two are supposed to be reset to tomorrow morning, assuming the paperwork comes through on them.
Just so you know.
Yes.
Mr. Renzo's bond was posted.
Which one?
Mr. Renzo.
Mr. Renzo's bond, I'm being told, has been posted. They're just waiting on the paperwork to come through.
And do you know anything about Mr. Fresher?
Anything about Mr. Fruster?
The clerk has no paperwork, we set for tomorrow morning.
Okay, that one's sitting at there's no paperwork, so he's being reset to tomorrow morning.
Yes, Judge, I'll let the deputies know.
Okay. All right, I do see we have an MO set on the misdemeanor docket for this afternoon.
Really, he's also on the felony second look.
Ah, okay. So then I'll hear what's going on with him. Okay, let's go to the hearing docket now. First up is going to be James Franklin.
He's approaching, Judge. He's here. Come on up.
Thank you. We've got the 2 cases for him. These are both second looks for him, correct?
Judge, he's on the misdemeanor docket, page 2. He's on the felony docket, page 4. And just to remind the court,
Yes.
probable cause was found for threat to specified individuals rather than corruption by threat.
Yes. All right, thank you. Good afternoon, Mr. Franklin.
Good afternoon, ma'am.
All right, so from what I'm seeing, it looks like his bond, the total bond is currently $1,500. Is that correct?
That is correct, Your Honor, and I spoke with Mr. Miller about this case, and frankly, my biggest concern is him showing up in court.
Okay.
It's not necessarily even the allegations themselves. As you can see on count 2, part of the reason he's before the court is because he didn't show up to his MO case. I see so far at least 1 capious arrest last year for failing to appear. I don't know if Mr. Romero has any information that can give the court confidence that Mr. Franklin will appear in court.
Judge, unfortunately, Mr. Franklin is homeless, so he doesn't have a mailing address. However, he did sign up with the public defender's office, so he's going to be assigned an attorney. So I will give him the contact information of our office so that hopefully he can keep in contact with his attorney so his attorney can apprise him of his future court dates. Number 2, we're going to try pretrial again. I know last year, from what Mr. Lender is saying, that didn't go so well, but hopefully in combination with public defender's office and with pretrial to apprise him of his court dates, hopefully that will keep him on track to come and show up to court and address these issues. But other than that, there's no one going to be able to post his bond, so he'll be here.
Just so the court's aware, I was looking at this capious case, the MO capious case.
Yes.
He was in community court. Judge Barner finally had to kick him out. He no-showed 3 separate times.
Okay. All right, so that's a problem for our purposes, for today's hearing. So, All right, in Mr. Franklin's case, I'm gonna leave the bond in place at this time. Next on our misdemeanor docket will be, Craig Mitchell Fizel.
Dane?
Does it show who he's gonna be residing with?
Judge, that's the gentleman, he's not here yet, I'll waive his appearance. My understanding, Judge, I believe he appeared before you yesterday, and I believe he was here on the weekend. I believe on the weekend, he was released on a battery offense, pretrial pending verification. My understanding yesterday, when I believe he was here, I did not know that, it was verified, so I was asking the court to consider, an ROR. But at this time, Judge, considering it's been verified, I'm gonna be asking the court on this, criminal mischief, if we could go ahead and do, pretrial, since it's been verified.
If we could have a moment.
Judge, I am looking at BSO pics, and it is showing pretrial Elmo for him.
Everyone's agreed on count one, it was always pretrial Elmo. The reason it wasn't dealt with yesterday is Your Honor was given the impression that he had nowhere to reside, so he couldn't be released.
Okay.
If I could, the only thing I'm just hoping to find out, if we can find out who he's gonna be residing with, I just wanna make sure, because this case involves his grandmother, the criminal mischief.
I understand.
And
All
which
right.
the court issued a no contact order. I just wanna make sure that there aren't any complications that, wires getting crossed and.
Okay,
Well, he was not pending verification, he was released outright GPS.
okay,
And order said stay 500 feet from the alleged victim.
okay.
We did speak to someone, not the alleged victim.
And not the alleged victim in this, because that was a battery, so was it confirmed that it wasn't the alleged victim from that case, or it was also confirmed not the alleged?
At that time, we had no knowledge of this alleged victim on that person.
And that's why I just want to make sure that they weren't speaking to Phyllis Ford. Okay.
Okay, so it's not the grandmother. Okay, so, no objection?
No.
All right, so I will ROR him to pretrial in this case. It'll be the same conditions. What is he on, a level 2 GPS?
Yes, sir.
All right, so he'll be ROR to pretrial, put on a level 2 GPS for this case, as he is on the other count.
Thank you.
Thank you. Yes. Okay, let's go over to the felony docket. First up will be Kevin Davis.
North Broward?
Thank you. It's a 30-day motion.
No problem.
Thank you. Good afternoon, Mr. Davis.
Good afternoon.
All right, this is a 30-day motion. State, have the charges been filed?
Not been filed as of yet, Your Honor.
All right,
I believe it's going to be a decline, but either way, he is entitled to an ROR at this time.
is there anything else holding him?
That I don't know.
No, ma'am.
Okay. Is there a no victim contact order already?
It may be an
There is, Your
injunction,
Honor.
Judge.
Looks like it.
There is, Your Honor, and if you want to advise them at this point in time that it's still in place, the notes in my system are indicating that there's an intent to decline charges. It just hasn't been formally done yet.
Okay. All right, so Mr. Davis, based on the information I've been given, you are entitled to an ROR on these charges today. I do want to advise you, since there was a no victim contact ordered already, that is going to remain in place for the time being. So once again, that no victim contact order means no being in the same place at the same time, no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, ma'am.
Okay, additionally, though you are being ROR'd today, I understand that Mr. Linder has stated it looks like the charges may be declined, but that has not happened as of yet, okay? That means
ma'am.
that it is your responsibility to keep in contact with your attorneys in the clerk's office so that you know if there are any future court dates that you need to be present for. You understand that?
Yes, ma'am.
Okay, all
Judge,
right,
before you close the book, can we
Yes.
just go sidebar 1 moment?
all right. Well, we're just gonna go off for 1 moment. Stay right there, Mr. Davis. All right, Mr. Davis, as I was saying with regard to the no victim contact order, you're not to have contact with the alleged victim. Based on the charges, it looks like there may be a current injunction for protection that is in place. I just want to remind you that if that is in fact in place, that you are to abide by the terms of that, whether the charges are declined or not in this case. If that protection order remains in effect, then you are to abide by it. Do you understand that?
Yes, ma'am.
Okay, all right, thank you very much. Good luck to you.
Yes, ma'am.
Okay, next will be Jakeem Lee.
Ain.
Thank you. This is a
He's
30-day.
approaching, Judge. Come on up, sir.
Yes, Judge.
Good afternoon, Mr. Lee.
Good afternoon.
All right, this is a 30-day motion. Have the charges been filed?
Yes, Judge.
All right, so Mr. Lee, these charges have been formally filed, which means your next step will be to go before your division judge for an arraignment hearing. Good luck to you, sir. Aaron Davis.
Conti, Judge.
Thank you. All right, good afternoon, Mr. Davis.
It's all
Good afternoon, Your Honor.
All right, this is a 30-day motion.
Yes, Your Honor. Information has been filed.
Has been filed. All right, so Mr. Davis, the state has advised me that the charge has been formally filed, which means your next step will be to go before your division judge for an arraignment hearing. All right,
Thank
good.
you, Your Honor.
You're welcome. Good luck.
Thanks.
Okay, next will be Paul Bendel.
North Broward.
Thank you. Thank you. All right, good afternoon, Mr. Bendel.
No, they didn't. They said they got me for no foul, right?
Well, we're about to find out. Don't get ahead of me. All right, this is a 30-day motion. Mr. Linder, have the charges been filed?
Yes.
All right, they have been filed.
Yes, Judge.
Okay, so Mr.
I don't
Bendel,
have nowhere to go anyway.
okay.
I don't have no housing on the outside, when I got released from December 20th on the institution, I didn't have no housing. I'm a man that sleep in the world, and I didn't sleep for 10 days in the world, and the institution released me with no housing, and then put me out of the Henderson Mental Health Center. I mean, I'm aware of the fact that, yes, I'm a man that sleep, but I didn't have no housing on the outside. I was sleeping on the sidewalk, but they're
Okay.
saying that I was a man who has to have a bed in the world.
Well,
And then today they came talking about they were trying to release me, because I was on the streets before.
Yes.
But like I am a man that sleep. I have it absolutely. My mother, Karen Bendel, I stayed with her for 20 years, but she don't want me at her house no more, and I have no other housing, and like I said, I'm a man that needs a bed.
I understand. Well, Mr. Bendel, let me just tell you, it looks like you will be having a bed for the time being, because what Mr. Linder has told me is that the state attorney's office did file these charges formally. That means that your next step will be to go before your division judge for an arraignment hearing. So for the time being, you will remain where you are, okay?
Right. What happens when I come up on the institution again, and the institution released me with no housing back to the same community where all this violence has been occurring, because they said that I've been smoking cocaine in
Well,
the
we're
neighborhood.
gonna find out, okay? We're gonna find out. I'm gonna have, when you go in front of your division judge, they will address that. And Mr. Miller, I'm not sure if any discussion's been had about maybe sending this to Judge Porth's division, but you might want to let his assigned attorney know that.
Certainly do so, Judge.
Okay.
Thank you.
All right. Good luck, Mr. Bendel. They're gonna get it worked out.
All right.
Good luck. Okay. Next is going to be Aaron Benita.
He's approaching, Judge. He's here at Maine.
Thank you. This is a second look. Okay, and I believe that Mr. Benita's bond is currently set at $1,000.
Yes, Judge.
All right.
Correct, Judge.
Okay. All right, who wants to go first?
Judge, unfortunately, he couldn't get in touch with anyone post his monetary bond. My understanding, he has very limited contact criminal justice system. I believe maybe his first arrest. He's been living here for 3.5 years in Hollywood. He lives by himself. He's 39 years old. We're asking if the court would consider releasing him in pretrial release.
Your Honor, I'm pulling up his record. I mean, one thing that I believe concerned the court is, according to his PC affidavit, he made a comment to law enforcement that I know, I always hold it, referring to the rental car, longer than it's due. I do it all the time.
Yes.
You had the vehicle since November 30th, or been taken November 30th.
And Judge, I believe it's a U-Haul. I
Yes.
believe he's been having it for about 5 months, and I believe he was trying to explain to the officer. I didn't read the PC affidavit, but my understanding is I believe it's happened before, and then he rectifies the situation with U-Haul and is current. But I don't know what happened this time. I don't know what the allegations are. But bottom line, I believe, if I heard correctly, I don't think Mr. Lender mentioned anything of his prior, so it leads me to believe that Mr. Benito, this is his first arrest ever, and that's why I'm asking for pretrial release on his behalf.
Okay, well, let me just go back to Mr. Linder and confirm whether he has priors.
I'm not showing any prior.
Where does Mr. Benito live, Mr. Romero?
Let the judge know where he reside.
At Ocean Drive, South
Okay.
Ocean Drive in Hollywood.
Okay, all right, that is the address that I'm showing in his information. Okay, I will ROR him to pretrial supervision. Mr. Benita, a couple of things that you need to understand, okay? Though you are going to be released today, you're getting that information that Mr. Romero just handed you. You must report to pretrial supervision within 24 hours. If you fail to report to them as I've instructed you, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
Okay. Additionally, as I'm sure is contained in the information you're being provided, this doesn't mean that's the end of the case. That means it's going to be your responsibility to keep in contact with your attorneys in the clerk's office so that you know about any future court dates you have to be present for, okay? Do you understand that?
Yes, ma'am.
All right. Thank you very much. Thank you. Next will be Dwayne Simmons.
Mr. Simmons, come on up, please.
Good afternoon, Mr. Simmons. Okay, Mr. Simmons is here in a second look as well. His bond is set at $750.
Judge, Mr. Simmons does have priors. However, no one's going to be able to afford to pay a $750 bond. He does have a place to stay. He lives with his father in Lauderhill, but his father's retired on Social Security, so he can't afford his bond. Mr. Simmons advised me he's looking for employment, but he has no financial means of posting bond. I believe this petty theft involves items taken from the Dollar General, I believe socks, something like that. But he can't pay the $750 bond, so he's asking to be released in pretrial.
Your Honor, Mr. Simmons does have priors. He also is, and I'm sure Mr. Romero knows this, has a pending felony for grand theft. Oh, come on. And I believe that's why the court kept the bond in place. He got a theft, 2016, that didn't get pled until May 29th of 2019. It would appear that there were failures to appear in that case. Or maybe it was resolved after he finished his prison sentence. 2016 grand theft auto, sentenced to just over 43 months, stayed prison as a habitual offender.
Judge, one other thing, and I haven't reviewed the PC affidavit. My understanding is Mr. Simmons never left the store. When he was, I believe, approached by LPO, he cooperated and did everything that he was asked of him.
Well, I'm just going to read you what the PC affidavit says. It says that when he was approached by the store employee, he removed the items from his pants, threw them on the ground, and fled the store through the back exit door when Cadet informed him she was going to call the police. Cadet called 911 and followed Simmons. She was on scene when he was detained and positively identified as the person that fled the store. Additionally, only because the issue was raised, it was not just socks that were stolen. It included 3 garden tools, 13 packs of socks, 4 Airwick air fresheners, and boot socks.
I would also just note the very last sentence, Your Honor.
Yes, I noticed. It appears there's an allegation He has stolen from this Dollar General multiple times and fled the scene each time before law enforcement arrived. Based on the information that's been provided to me, I am going to leave the $750 bond in place at this time. Thank you. All right, that brings us to the end of our docket for today. I thank everyone, and I'll see you all back here tomorrow morning. Yes, but do we have something additional we need to address?
Judge Brittany Ferry, case 19012734MM10A.
Yes.
That case was supposed to have been on the 30-day docket. Mr. Linder brought this to my attention.
For some reason, Your Honor, and I'm not sure why,
Okay,
when the public defender sends out their email with the 30 days,
yes,
anytime there's misdemeanors, they never seem to make it on the misdemeanor docket the next day. But
okay,
the defendant, Mr. Miller, is referring to was noticed for a motion to release. I've been advised by the case filer that she's not going to be filing the charge.
okay.
I have no objection to an ROR.
Is, which facility is Miss Ferry at? Oh, here we go. Okay, all right, hi, Miss Ferry.
Hello.
Okay, so the charges have not been filed, you said?
They have not, Your Honor. And for the record, this would be case number 19-12734 MM10A.
Okay. Is there anything else holding Miss Ferry?
I'll check.
I just want to
I
make sure.
don't believe there is, but I'm.
I got it. See whose computer works faster.
Not according to BSO picks, Judge.
Okay.
Computers were keeping this slow.
All right, so Ms. Ferry, based on the information that I have been provided, you are entitled to an ROR, which means that you will be released today. Based on what Mr. Linder's telling me, I'm not sure if the charge will be filed or not, but for the time being, please understand that though you're being released today, that does not necessarily mean that's the end of the case. So it will be your responsibility to be in contact with your attorneys in the clerk's office so that you know if there are any future court dates you have to be present for. Do you understand that?
Yes.
Okay, all right, thank you, ma'am. Good luck to you. I'm going to sign the order now.
Miss Ferry, you should probably thank the detention deputy for calling us to make sure that we got this heard today.
Thank you very much.
Thank you. Thank you, deputy.
Bye-bye. Take care.
All right, is there anything else before we get off the record?
No, Judge.
Okay. All right, thank you, everyone.
Thank you, Judge.